Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of these stories, download our News In document using the link in the top right hand corner of the screen. Companies House has announced that from the 26th of June, companies must update their persons with significant control registers within 14 days of the change and notify Companies House within a further 14 days. In addition, the entities required to make such notifications will be increased. The Department for Business, Energy and Industrial Strategy, BEIS, intends to implement a similar transparency register to identify who controls certain overseas legal entities that own UK property or participate in a significant UK public procurement. A call for evidence has been published. BEIS has published its report on corporate governance. The recommendations include the Corporate Governance Code to require informative reporting on how directors have complied with their duty to promote the success of the company, an extension of the reporting requirements to private companies, and half of all new appointments to senior and executive management level positions in the FTSE 350 and listed companies to be women by mid-2020. Next year, the exposure to fines for data security breaches will be increased by the EU Data Protection Regulation and the lesser-known EU NIS Directive. This directive is intended to ensure that there are minimum cyber security standards for operators of essential services. We are still waiting for clarification on penalties and details of the entities covered. Indirect discrimination occurs when an employer implements a provision, criterion or practice, a PCP, which affects the entire workforce but puts an employee with a certain protected characteristic, e.g. gender, race or disability, at a disadvantage compared with others. The Supreme Court has ruled in two recent cases that an individual claiming indirect discrimination does not need to explain why the PCP discriminates against certain groups of people. In Aesop v Home Office, it was held that there had been indirect discrimination when a report revealed that employees from a certain race and older employees were not passing the assessments as frequently as white and younger employees. It did not matter that no one could explain why this was the case. It is still open for employers to argue that the PCP can be objectively justified. We have regularly reported on the holiday pay saga and particularly whether average commission pay should be paid during holiday periods. The Employment Rights Act has already been amended to limit most backdated claims to 2 years, but a recent decision places further limitations on these claims to any gap of 3 months between successive underpayments. There are complex rules on how the 3-month gap is calculated, and if the claim is made as a breach of contract claim, the limit will not apply. The Work and Pensions Parliamentary Committee into the inquiry into the gig economy has published its report. The report lists some of the practice that it sees as blurring the line between employment and self-employment and notes that there is a substantial burden on workers if they wish to challenge their status. The committee recommends that in such cases, worker status is the default position. The committee also asks that the incoming government sets out a roadmap for equalising national insurance contributions made by employees and the self-employed. The recent case of Bourne London v Spire Production Services held that under a TUPE transfer, the information that the transferor employer must provide to the transferee employer includes contractual and non-contractual entitlements paid to employees, but does not require the transferor employer to detail which entitlements fall into which category. Transferee employers must do their own due diligence to understand the detail. The Court of Appeal has upheld a High Court decision that the shape of the Kit Kat is not distinctive enough to warrant trademark protection in the UK. The reason for this finding is that whilst consumers may associate the shape of the Kit Kat bar with Nestlé, it is recognised more by its bold red branding. It can be dangerous to threaten intellectual property infringement for patents, trademarks and designs, as there is a right to bring an action against the person making the threat by any person that feels aggrieved by it. This shifts the burden on the person making the threat to prove its claim at the outset. The new Intellectual Property Unjustified Threats Act of 2017, which is likely to be enforced in the autumn, clarifies what can be a threat, but also allows for permitted communications for permitted purposes which cannot be threats. Most developed countries have a merger control regime which allows the competition authorities to examine whether a merger may have anti-competitive effects. Recent cases have shown that by misleading the authorities, jumping the gun or failing to notify relevant mergers can lead to substantial fines and even having a clearance revoked. Perhaps the most publicised case has been Facebook's acquisition of WhatsApp in 2014. In this case, the Commission found that Facebook had provided misleading information. Whilst this did not impact the clearance decision, Facebook was still fined €110 million. The European Commission has finalised its inquiry into the e-commerce sector. Here's a summary. There is no intention to change the current legal framework for distribution agreements. A requirement to operate bricks and mortar stores should be objectively justified. Manufacturers placing pricing restrictions on retailers are hardcore violations of competition laws. Online price transparency has encouraged competition, but there are concerns that this facilitates anti-competitive behaviour. A ban on the use of marketplaces such as Amazon and eBay is not a hardcore breach of competition laws, but note other national competition authorities disagree, and this issue is pending before the European Court of Justice in the Coty case. Geo-blocking, the practice of preventing consumers from making cross-border sales, is illegal when they arise due to agreements between businesses. The Criminal Finance Act of 2017 is expected to be law in the autumn. A company will be liable if any of its employees or representatives assist others to evade tax, unless it can show it has reasonable prevention procedures in place. The Act also makes some changes to the suspicious activity report regime and allows for certain regulated firms to share information, and implements the unexplained wealth orders regime, which allows the High Court to demand a respondent to provide information about the ownership of property. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in July with more of the month's key legal updates.